Oh, no, not doing anything.
All right, good morning. All right. Where?
No.
Oh, you need it. Go ahead, I'll wait for you to put that on. Can you hear me?
Yes, sir.
Got it. Okay. All right, where are we on this?
We've been here on a few different adjournments. I think this was the date and time set for the last settlement conference. Defendants requested a jury trial. There was an escrow order that was put in place January 5th. That escrow order, though the sums have been paid properly, the timing of the order was breached. It's required to pay rent within the same time period as the lease, either the 1st or late by the 5th. We have escrow payments that were made February 15th, February 16th, that would have been late for the month of February, which would result in the waiver of the jury. So as a result, if the court is still inclined to proceed forward with the trial, it should just be a bench trial at this point. It should be set relatively quickly. I believe the escrow order would have required it to be set within 14 days. We have filed an answer. The court had adjourned previously when the defendant filed an answer to this, that their affirmative defenses could have been read as counterclaims. So we did file an answer to the end to avoidance of the affirmative defenses with the court. Ready to proceed now, though I still don't think there's a tribal issue of fact. I know the court has allowed it to go this far and is granting her the jury trial.
Do you have a response?
Yes, Your Honor, I believe that there are tribal issues. I can prove with evidence retaliatory eviction, illegal lockout, changing locks. I communicated the need for repairs, gave plenty of time. They were not done. This ultimately stems from a personal dispute by Ms. Serena's husband. I have been trying to get help from state emergency relief. I had to wait a little while for my appointment, and I had it last week. And thank God I was approved for some support up to $3,000, but the landlord refused to accept it. There has been no serious health hazard done, and they will not be able to prove that such a thing occurred. I will be able to share context.
Well, let me ask this. And it's a rather odd termination because one of the things is a failure to pay rent that was on there. But that aside, have the health hazards that were alleged, have they been corrected?
No, I've been living in this winter with a broken window. I have been living without a thermostat because the landlord took it away. It's one of those Wi-Fi thermostats. Mitch.
What do you mean they took it away?
So
it's a three level unit, Your Honor. The thermostat is in one of the other units, which is set to 72 degrees and stays there. She's never had access to the thermostat.
That's not true. When I moved in for 5 months, I did have a thermostat that I used, and I keep different hours. I'm disabled. I tend to be more awake at night when their schedule fits probably more of a 9 to 5. So what's happening is at night, the house is freezing cold when I'm trying to accomplish things. I've had issues with the lighting in several areas where.
Hold on.
Yes,
Hold
sir.
on. In terms of the rental balance, so maybe we can get that part. What is the balance that you're claiming is owed?
The balance of rent, not including the escrow, Your Honor, would have been $5,390 through this month. I do believe escrow was paid this month, sometime around March 1st for $980. Otherwise,
well, I don't have $980 in rent. Unless some came out. I have $870, which was paid on the.
Oh, yes, sir, because last month I paid a little extra ahead. So when I was here to make my payment, I asked the clerk to tell me the amount that was paid extra. So if the total balance should reflect the 3 months.
It may. I'm just saying, counsel had indicated a certain amount had been paid, and I'm indicating there was $870 paid.
the full amount was paid in pieces. Yes, sir.
From the onset of this case, Your Honor, it's $6,370 in total rent paid.
Say again.
$6,370 would be the rent due and owing.
6,300. Give me that
70.
$70.
Just so the court is aware too, the lease expires April 30th.
What do you have as the amount of rent?
I have $2,939.98.
All right. So the lease expires April 30th.
Correct, John.
Are you intending on moving, or what is the?
Yes,
Okay.
I wanted to stay at my apartment.
Pardon?
I wanted to live in my apartment for the full lease term. I'm planning to move out at the end of April.
Okay. All right.
So I would like to see proper accounting of the claim of that amount, because the last time I was requested, it was not done properly. And
What do you mean the last time? I'm not sure what you're.
The hearing begins with a defendant walking into the courtroom acting confused and unprepared. Judge Simpson asks a simple question about the defendant's charges, but the man gives an answer that makes absolutely no sense. He rambles, blames everyone else, and insists that none of this is my fault, without explaining anything clearly. Judge Simpson leans back in his chair, visibly stunned by how disconnected the defendant is from reality. The courtroom goes quiet as everyone realizes the judge is hearing one of the strangest explanations ever brought before him.
Referring to.
At the December 22nd hearing, Your Honor, defendant requested an accounting of the rents that were paid. We did a notice of filing showing both her payments as well as the payments of her prior co-tenant, because
that
it
is
was
not true. That is not true. I have not received that. That's what I asked
Hold
for.
on.
Yes,
Okay.
I'm trying very hard.
Okay. And you're saying you didn't receive it.
I did not receive anything that reflected what my roommate contributed. I did not see that. What Attorney Backman just said.
And
It's
Your
not
Honor,
true.
that was addressed at the last hearing where
I
she indicated that
thought it was.
a proper accounting. She didn't like the way the accounting was drafted, but it was in and of itself an accounting of all of the rents paid by both sides, showing.
And maybe we review it together.
We who?
He's saying it is, I'm saying it ain't. Let's,
Okay. Here, I think that's what let me put it this way. What I'm looking is what issues at trial I'm going to have to deal with. Obviously, I'm going to have to deal with that. So,
I have an additional copy, Your Honor, for the defendant, so I'll make sure.
Okay.
yeah, and I heard you said is this the answer? Because I didn't receive any additional information. You said you filed with the court.
Your Honor, I have an additional copy of the answer to the affirmative defense.
I mean, how do I get that?
These were all mailed, Your Honor.
Well, they haven't been received yet.
okay, now they have. All right. So what the court's going to find regarding trial, because obviously we're not going to be able to resolve it here at a final settlement conference, is that given the way that escrow was paid, the problem is that escrow needed to be paid within the time frame specified, and it wasn't. It was paid, all
I
right,
didn't
but you
know
have
that,
to.
yeah.
No, I'm not faulting you for that. I'm just saying.
Which month was it? Because this month I came in as soon as I got my social security deposit. I only get the one amount per month. And
No, I get it. I mean, it's not, but what I'm saying is there's timeframes for it to be paid. What I did is I think that the jury has been waived.
Correct, Your Honor.
And so that's it. That doesn't mean that you don't get a trial. I delayed it in terms of what would normally happen is I would have said, jury's waived, they get an immediate trial. The problem is you had not yet gotten all of your things together to get to the court. And so I was allowing that to happen. That doesn't really affect the waiver. It more affects the timing of the trial and then the payments. So There will be a trial on possession. I will set a trial on possession. Here is my real fundamental question for the parties, because I can get you in. It's going to be sometime in April. And realistically, just thinking, the lease expires April 30th, right? There'd be a trial. We could certainly spend our time on a trial or agree to a move out at the end of April, because I mean, you're going to somehow or another, you're going to have to figure out the figures of what may be owed, right?
I can do
But, and I know you can do that. You're going to come to a different number than that. I know how I've been with you guys long enough. I know what's gonna happen. So, but what I'm saying, I guess my bottom line to it is I'll give a trial date. That's not a problem. But the reality is you're going to be moving out at the end of April, right? And that's what they're looking to have happen. I don't know why we can't just figure everything out with a move out date of April.
And I'm okay with that. I would be willing to negotiate with them, but after I got the approval, they said, yeah, we're going to help you with the 3,000 from SOS. The total amount that I had was just under 3,000. So here I am happy. I'm going to get some support.
Hold on a second. So did they say they were going to do that?
Yes, I have the email that I can share with the court. Miss Alicia, last name.
So Alicia, that's fine.
Yeah,
from SOS.
Yeah, and I have a letter that states the landlord declined to participate in the program. So they're suing me for money. I was able to get money, but they don't want to come and I was Alicia basically said, which is my I had an email. It says that, I'd been waiting all this time for the extra help. So they're kind of just throwing everything on the wall to see what sticks. They're claiming rent, but the rent was withheld because of a failure to secure a property that's habitable. The landlord busted off the locks. I lived without locks in my apartment for several months. I had people break in.
I'm not here to try this right now. Okay. If you say that there's assistance, they declined to participate in the program, then I can't do anything about that. I can't force them to do that.
Yeah, it's just odd, right?
Pardon?
It's odd.
It's not necessarily odd. I mean, some landlords participate, some don't.
I'll speak with my clients as the first.
I was wondering if they should contact Zorica instead of Mitch, because Mitch is the rude.
All that aside, Your Honor, I don't know if the court would prefer, given that there's an indication from the defendant that should be moving out at the end of the month, to set the trial in May, just not to waste the court's time. I hate to kick this out any further. My fear is that we'll have the issue over not just possession, but damages and rent. That'll be the bigger.
Because there wasn't a permanent ongoing problem.
So possession is already handled. Setting it in may save the court time.
Do you have any problem with me setting a May trial date then instead of an April one?
I preferred the jury trial that I requested.
I know, and I'm deeming that it's been waived.
Okay.
So
I'm willing to be at trial whenever is convenient for the court.
Okay.
Judge Simpson tries to give the defendant another chance to explain himself. Instead of answering directly, the man starts bringing up irrelevant stories, unrelated people, and wild claims that have nothing to do with the case. At one point, he even contradicts his own statement from a few seconds earlier. Judge Simpson actually pauses, staring at him in disbelief. He asks, "Are you listening to yourself right now?" The courtroom...
But what counsel's suggesting is a May trial date, because you said you're going to move in April. And so it may be that the trial may not be necessary. It can be resolved that way.
Because it's a retaliatory eviction and I want my damages.
I get that.
Yeah.
But the certain issues regarding possession and other things would be done with if I set it in May. as opposed to if I said it, it's going to be early April. And here's what I don't want to run into potentially is a situation where, let's say, and I'm not saying how I'm going to rule, but I'm just saying, let's say I rule in their favor. And then there's an order of eviction for, let's say, April 15th. And then, but you're going to be out the 30th anyway.
I'd be willing to be out tomorrow if they would just accept the $3,000 and say I don't owe them any money and we move on. It's only a month left.
Okay.
Otherwise,
then that may be an option you guys can work out. And let me just say this: I don't know this for sure. Part of the reason why they may not have accepted the 3,000 is because the funding technically is to preserve housing. So the question of you moving out at a particular point in time may affect that 3,000 and whether or not they pay it.
Okay.
Okay, well, it's a hypothetical, but it depends on what program it's coming from, is what I'm saying. So it may be that it's not entirely as simple as that, because what used to happen is somebody would get an email like you did. They'd contact the landlord, and what they want is then a lease that continues on. And if the landlord said, no, that's not going to happen, that will look like their rejection. I'm just saying, I don't know that happened in this case, but I could see that potentially being an issue in this case. All right.
Potential, not possible.
Okay, however you want to phrase it. All right. So here's what I'm going to do. I'm going to indicate the jury trial's been waived. I think the best thing to do, folks.
So what month was it that I missed the window?
Well, actually, the first period in time, you actually would have missed it.
The first period when it was first ordered?
Yes, ma'am.
It was ordered after the payment due date, wasn't it? We're talking about.
Well, there was a escrow was prorated, and then when you came into hold on. When you came into February, you did a partial.
I've already.
And then, if you're going to try to overtalk me, I can't do it that way.
How else may I respond to things that I'm concerned about? I don't have. I will write them down.
All right. That's my ruling on it. I'm also going to then set non-jury trial in this matter. Give me a May date. I need it before then.
Do Tuesday, May 7th, you know?
Thank you. That non-jury trial, May 7th, 2024 at 9 a.m. Right. And that's what we do. And you're going to check into with SOS.
Yeah, sure.
And that.
Do you have their contact info? I can share with you.
That's what I was going to suggest. If you can get the contact information so council knows, and then that way maybe that'll work out that back amount in some way. Okay.
Thank you, Your Honor.
Thank you. We do the same. Hearing on escrow.
It is, Your Honor. Just to refresh the court's recollection here, there's escrow, and there was also rent wasn't paid for September, October, and November in this case. we proposed to just have escrow released to the landlord and call it a day. We moved him to a new unit, and he refused. So I do have Amy Tu here in case the court wants to hear from her with respect to any issues. But the tenant lived in the premises for 3 months and didn't pay rent. This is one where he did make a complaint to the landlord in August, and then it was not dealt with, admittedly. Never heard from him again until the end of November when the city notified us that he should be moved from the unit. But he lived there for the 3 months. So our resolution was just release escrow and move on, but he's refusing.
It's my understanding that Arbor One dropped the complaint and the case was dismissed after my apartment was condemned by the city. So I was thinking the escrow would be released back to me.
Your Honor, we dismissed the case because we moved him to another unit.
Correct.
And they have not yet.
So you want to go to trial over the $968?
I suppose, yes.
So let me ask you this. For the 3 months you didn't pay, you still did you move yourself someplace else?
No. I was still living in the apartment, which was
Okay.
had a major
You're still living there.
condition with
You
mold.
still had your property there.
Yes.
So in essence, prior to them they're moving you, sir. I mean, I'm just going to give you a perspective on it.
The situation gets even stranger. The defendant begins arguing with the judge, insisting he knows the law, even though nothing he says matches the actual legal process. Judge Simpson remains calm but clearly shocked, repeating the question in the simplest terms possible. Yet the defendant continues spiraling into nonsense, blaming the system, blaming the police, and even blaming the judge for things he never said. The judge finally shakes his head in disbelief, realizing that the defendant truly has no understanding of the situation he is in.
You're asking for 100% abatement for those 3 months.
Because the apartment was in such poor condition.
Okay. An apartment can be in poor condition, and if you want a trial, I mean, I'll give you a trial on it. I'm just giving you perspective that I don't think I've ever ordered 100% abatement where a tenant hasn't moved out of the unit. So the very fact that you're there, all the money's not coming back. I mean, it's just not. I mean, what they're proposing is basically a 2/3 abatement, which typically itself can be high from what this court has previously ordered. You follow me?
I think so. It was just
So
my
what do you
understanding.
think I just said?
It was my understanding that the case was dismissed. That they dropped the
Because
complaint.
you went to another unit.
They moved me to another unit after my previous unit was
What
condemned.
I have to determine, because escrow was paid, is where the escrow goes. You're thinking it should come back to you because the case is dismissed. That's not always what happens.
Okay.
Okay. If that's your basis for it, I would be looking at the basis of, or I would be looking at for that 3-month period, what was your use of the premises? That's how I'd be looking at it. And so really what plaintiff is saying is they're willing to call it a day, just saying that it's 1/3 use of the premises that you had. You could get to a trial. It's a possibility. I'm not making a finding, but you could get to a trial where I come to the conclusion that you had half use of the premises. Here's going to be the problem with that for you, is that then the entire escrow would be released to the plaintiff and you would then likely owe them money. That's a possibility.
Possible.
It's also a possibility I could find that you had absolutely no use of the premises. It's going to be a bit hard to find that given the fact that you were residing there. So, what do you want to do?
I don't feel that I owe them the money.
You want a trial?
Yes.
Okay.
And just so we're clear, Your Honor, we will be seeking the full balance at trial. Just
I
okay.
understand that. I tried to explain that to him.
Okay.
You understand that, sir?
What was that?
They're going to be seeking the full balance
Okay.
at trial.
I feel with what I filed before with all the photos and
I know how you may feel. I'm just need you to understand they're going to be trying to come after you for the full amount. Right?
okay.
I don't know that they'll get there. That's fine. But they're going to be coming after you for the full amount. You understand that?
Yes.
Do you? Okay. So just so that you're clear, the realm of possibilities are that you could end up owing money or owing nothing. And you're rejecting their offer just to give them the escrow and call it a day. And basically, in essence, you wouldn't be paying for 2 months.
Okay. That's what they're offering right now.
That's what they're offering right now. I don't think it's going to get any better, but
Okay. I guess I will accept that.
that just to pay the escrow to them and call it a day.
And then that case is dismissed.
Then everything is done.
Okay.
Is that what you want to do?
Yes.
Escrow is released to the plaintiff. Case is dismissed. Okay, so the case is dismissed. I'm releasing the escrow to the plaintiff. We're all done.
Okay.
Okay, you good with that?
Yes.
Okay, fantastic.
Thank you, Your Honor.
It's a pleasure. Take care.
Thank you, Your Honor.
Thank you.
Have a good day.
You do the same.
Thanks.
What am I doing now?
That's a review.
This is a review. This is
Judge Simpson finally brings a hearing back under control. He explains the law step by step and clarifies the charges in plain language, but the defendant still tries to argue with irrational logic. At this point, the judge lays down a firm decision on bond, court dates, and consequences. His expression says everything. He simply cannot believe the level of confusion and absurdity he just heard. The clip ends with the judge issuing a final warning and the defendant being escorted out, leaving the entire courtroom stunned.